Mental health disabilities in the workplace. What are your rights? What can you do? There are a lot of things you can do. And if you're watching this now and you're an employee and you're suffering from mental health disabilities or mental health conditions and you need some accommodations, but you don't know exactly how to go about that, or if your mental health condition even qualifies as a disability, please keep watching. My name is Tracy Lewis. I'm an employment lawyer with Leeds Law Firm, and I think it's really important that we understand, especially employees out there in the workplace, understand what their rights are when it comes to reasonable accommodations related to mental health. A lot of times we hear about, or we may be more knowledgeable about what accommodations are available when we have a physical ailment, but it's not as clear when you have a mental health condition, but that's just as serious, right? And we see it all the time. We see it in the media, we see it in our own personal lives that mental health is real and you don't have to suffer in silence. You can be what we call in the law a qualified individual with a disability when you have a mental health condition where you can work, but you just need some reasonable accommodations to do so. So, this video is for informational purposes only. Although I am an attorney, I am not your attorney, so I have to say that if you feel like after watching this video that you might really need some legal representation to deal with your situation, make sure that you reach out to a qualified employment lawyer in your area so that you can get actual legal advice. Because again, this is not legal advice. Although I'm an attorney, this video is for informational purposes only. So now that we got that out of the way, let's get into it. Let's start talking about mental health disabilities in the workplace and what reasonable accommodations might be available to you. So let's talk about a scenario where an employee has found out that they are suffering from anxiety. And the anxiety condition is so serious that it's starting to affect their ability to sleep. They're needing professional mental health treatment, which could be come in the form of therapy or actual medication prescribed by a doctor or a psychiatrist. And they feel the need that they may need additional accommodations at work. So, this employee finds out they're suffering from anxiety and informs the employer that this is a mental health condition that they're suffering from and that they need some accommodations. Now, let's use medical leave as a form of an accommodation. The person is suffering from anxiety. Their treatment plan is going to be that they have to go to therapy 3 times a week and take certain medications. So, in order to go to therapy 3 times a week, they're going to need some accommodations in order to go to their therapy appointments. So, they let their employer know they have anxiety, they've been diagnosed with this, and what do they need to do to get some accommodations to be able to go to therapy treatment 3 times a week. Maybe they can do one of the treatments on Saturday and the other two treatments need to be during the week. So, in the law, anxiety can be a disability if it interferes with what we call a major life function. Um, there are many different levels of anxiety, but some people really have severe anxiety that interferes with their ability to operate mental functions, to sleep, to work, to do things like that, which are major life activities, right? So, a mental health disability like that can be just that, a disability under the law, under the Americans with Disabilities Act. And here in Texas, we also have state protections for people, state law protections for people with disabilities. So things like anxiety, depression, bipolar disorder, these are all mental health conditions that can qualify as disabilities in certain circumstances. So employee reports this to the company and they need some accommodations. Now, with mental health disabilities, accommodations could be leave from work in order to get psychiatric treatment. It could be I need additional time to complete tasks. So, you would work with your employer to see what accommodation is reasonable. Now, we talked about notification, right? Notification is really, really important. And of course we know these are personal situations, so you want to your personal medical information to be kept private, and that is a realistic expectation. And also under the law, your employer should not be sharing your medical information with, let's say, coworkers or other employees that don't need to know. It should be on a need to know basis, and you should have that expectation that your medical information is kept private. So usually, typically, a human resources department would be handling this type of information. But your supervisor or manager may need to know as well, because they're going to be the ones working directly with you to see what accommodations the company can provide. Okay, so you reported that you have this disability, and now you're going through what we call the interactive process. What the company should do is they should talk with you and say, okay, these are the things that we may need from you. One thing that the company might need from you is a medical certification or some type of medical document. It could be in the form of a doctor's note that says what type of disability you have and what reasonable accommodation you need and for how long. So step one was notification. Step two might be what we can call certification. The employer is asking you questions about what disability you have and wanting medical documentation. I get calls from potential clients all the time where they're concerned that they feel like the company is digging a little bit too much into their personal medical history, because they notify that they need a reasonable accommodation. The reality is, the law says that for the company to engage in what we call the interactive process, in order to see if they can get you the reasonable accommodation that you need, they are allowed to ask for medical information. So don't get too alarmed if your company is asking you to provide medical documentation. The goal should be to get you what you need. And sometimes you need a medical doctor to help you with that by saying what your diagnosis is and providing that information to the company. Okay, so we talked about notification, letting the company know you have a disability, then certification, providing the necessary medical documents to support the reasonable accommodation you're asking for. When you work with your doctors to help you get a reasonable accommodation at work, you want to really talk to them and see if they can put in the doctor's note very specific restrictions or accommodations that you might need. One really important thing to protect your job in these circumstances is to make sure that your doctor puts in the doctor's note or medical certification the frequency of the reasonable accommodation you need and how long you may need it for. Now, let's say in my anxiety example, you may need reasonable accommodations for the entire time you're working there, but you may have to kind of recertify like during periodically. So let's say your first doctor's note says, here's the treatment plan. These are the reasonable accommodations that the employee will need, and this is going to be for the next 3 months. And then we're going to have a doctor's appointment on whatever date and reevaluate. So this gives your employer a set amount of time, or it gives your employer notice of the time period that you might need this accommodation and that you are currently under doctor's care. So that makes it easier for the employer to assess whether or not this reasonable accommodation can be given to you, and if you're going to be able to do all the essential functions of your job with this reasonable accommodation. So that leads me to kind of the last part I want to talk about in this segment is essential job functions, right? There are certain things that your job requires you to do. Even as a person with a disability, you have to be able to perform those essential job functions with your accommodation. So let's say you need extra time to complete tasks, that's fine. You're still going to be able to complete all of your essential job functions. So if you're working as administrative assistant, you can still do all those job functions even with your mental health disability. So let's say you're going to do therapy sessions, that doesn't mean you can't do your job. You just need this leave intermittently during the week, maybe an hour on Monday, let's say an hour on Wednesday to go do your therapy, and then you're still going to be able to get all your work done. So that means the employer can't say, well, I have to fire you because you're not able to do this job. That's not true. You can do the job, you just need reasonable accommodations, and that's what the law is there to protect, right? People with disabilities can work just fine, just in certain circumstances they may need accommodations, and if those accommodations can be provided without the company undergoing what we call an undue hardship, meaning the company can't function or your department can't function if we give you these reasonable accommodations, then they really need to provide those accommodations to you. That's what the law was created for. You notify that you have a disability and you need certain accommodations. You work with the company works with you. You get those accommodations and you're able to continue working. So the reality is, if you have a mental health disability and you think you need reasonable accommodations, don't wait until maybe your performance at your job is suffering and management is thinking, hey, they're just not getting the job done. They have performance issues. Don't let that happen first. You want to get ahead of it. You want to notify your employer that you might have a mental health disability, get treatment from a doctor or a mental health professional, and then notify the company about what reasonable accommodations you might need, and keep everything documented. I always tell my clients, anything that you can put in writing, you want to, even if it's a text message to a manager or an email to human resources. It helps because if later on down the line anything negative happens to you, let's say the company is not doing what they're supposed to do under the law, you have a paper trail. I emailed, I let them know I had a disability. I emailed them my doctor's notes. I messaged the doctor's appointments that I would have. I went through the company's protocol as far as notifying about doctor's appointments in advance, all that good stuff. Keep it in writing. It would only help you in the future if anything negative was to happen. Now, hopefully, the company does what they're supposed to do, but obviously, as an employment discrimination lawyer, I see the opposite happen all the time. So, notify, certify, work within the interactive process to see if you can get a reasonable accommodation, and make sure you put everything in writing. So that is just kind of an overview of reasonable accommodations, especially when you're dealing with mental health. But like I said in the beginning, if you feel like you need legal representation, make sure you contact an employment lawyer in your area so that they can advise you as to what legal rights you have. If you like this video, make sure you hit that like button and also hit subscribe. Lee's Law Firm posts new videos every single month, so we will have different content on all different employment law topics, and we hope that we can help people looking for information, because everybody has to work in some form or fashion, but we want to make sure that workers' rights are protected.